I probably have the award for the longest title for any talk today. Probably got the most number of slides as well, so I'll try to rattle through them very much as a bit of an overview. So what we're looking at really is to do with the UK predominantly, England, but also Jersey, and look whether these two different jurisdictions are actually compliant with international, local agreements to do with protection of bat species. And also looking at bat crime itself. So are any of the things that when bats have actually been been part of a case, what have the fines been and what can be done to try to make bat crime not be committed? Can we use a financial penalty better? So the contents really are a brief overview of the laws protecting wildlife and bats in both England and Jersey. Overview of the main conventions that protect bats and wildlife and bats. More detailed discussion looking at Eurobats and the resolutions under Eurobats, which predominantly look at lighting, climate change and insulation and lining materials. So this is where we start seeing humans, climate change and bat conservation coming into a bit of a conflict. A review of bat crime cases in the UK. This is mainly because in Jersey there's been no bat crimes taken to court locally. Nobody's ever been prosecuted. Bats have only been mentioned once in our local courts, and that was in a planning objection case. And just come on to the conclusions, just a summary of what I've spoken about, if I've got time by then. So really just start with an overview of history of bat protection. So bats have undergone massive historic declines. So there was some time in the 1950s where it was thought that some local populations of bats in some countries in Europe would go locally extinct. And this was due to many different reasons, but predominantly because of humans. So this is changes in development, changes in land use, using insecticides, using pesticides. So all of these things were causing massive declines in bats. But it wasn't until 1975 in the UK that two bats were actually protected, and this was under the Wild Creatures Act of 1975, where it became an offence to kill, injure, take or attempt to do so of the two bat species mentioned here, which are greater horseshoe bats and also greater mouse-eared bats. And the interesting reason, I don't know why they chose these species, the greater mouse-eared bat by that point was found to have one individual left in the UK, and greater horseshoes were quite rare as well. So they picked just the two species of bat to start with. Next sort of step forward was really to do with the Berne Convention. And this was a convention on the conservation of European wildlife. And this was adopted in 1979 and came into force in 1982. And within the Berne Convention, it became a requirement for signatories to take appropriate and necessary legislative and administrative measures to ensure the special protection of wild fauna species specified in Appendix 2, with deliberate capture and keeping and deliberate killing or deliberate damage or destruction of breeding and resting sites, and the deliberate disturbance of wild fauna, particularly during the periods of breeding, rearing and hibernation, all becoming offences under this particular convention. And for this point, all bat species that were in Europe were protected under this particular convention, apart from common pipistrelles, because they fell into a different appendices where they had slightly lesser protection than this. In the same year, interestingly, a good year for environmental law, there was the convention in Bonn, again in Germany. And this was looking at migratory species. So this is called the CMS, or Bonn Convention, and its aims were to preserve terrestrial, marine and avian migratory species throughout their range. So it's a platform for looking at these species that move between countries and trying to actually protect them across their whole range. There's not much point protecting them in one country if then in other countries things can happen to them then. Now, this actually has a different annex. You think the two conventions might have spoken to each other, but this Annex 2 included all European species of bats and included everything, including the common pipistrelles. So they were all under one particular annex. Now in 1981, the UK decided to meet its obligations imposed by Berne and Bonn and transpose those two international conventions into UK law using the Countryside and Wildlife Act. And so all of those species of bats were given the protection under one annex rather than the two-tiered system that were under the Berne Convention. So they followed Bonn. So common pipistrelles are as protected as other bat species. So this was the first time that all bat species in the UK were afforded a degree of protection. In 1991, a particular agreement was actually undertaken, which is under Article 4 of the Bonn Convention. And this was Eurobats. And this is a legally binding agreement to ensure that signatories, and these are the key words, endeavour, not the best word in European conservation, comply with the obligations noted in Annex 3 of the agreement. And this aims to instill more protection on bats across the European range. It doesn't just apply to Europe, this particular agreement, it goes outside that. But it's an interesting one really, because it was transposed into the UK under a slightly different law. We'll come on to that in a minute. So the Wildlife and Countryside Act itself, if we can keep up, was amended by the Countryside Rights of Way Act in 2000, so quite 21 years ago. And this actually added the word recklessly into the text of the Wildlife and Countryside Act. Interestingly, it didn't make it into our legislation at that time, as well as actually undertaking acts intentionally against bats. So you could be recklessly causing disturbance or killing or taking, as well as actually intentionally doing so. And it also reworded some parts of the law with some protections from bats moved out of the wildlife law itself and moved into a different law, which was the habitats regulations. Now, these came in and they were amended several times. And it's interesting because one of the amendments under this law was because of the EU taking the UK to court. So there was a commission case against the United Kingdom that ruled that species protection provisions in the habitat regulations that the UK had enacted were not compatible with the strict species protection regime required by Article 12 of the Habitats Directive. So what this meant was that the UK had within its law that you could have an incidental results defence under the law. So if you undertook something, but it was an incidental result of a lawful operation, then it wasn't an offence. And Europeans said, no, this is not how we envisaged the Habitats Directive and Habitats regulations to be. So what happened was changes to UK domestic regulations. So what you've essentially got in the UK are two laws protecting bats. And how this came about was that the Wildlife and Countryside Act in 1981 was the UK as a sovereign nation enacting the conventions itself into law. Now, they had to do this again when the EU then, as a entity, then ratified these different conventions and had their Habitats Directive, which the UK then had to enact in UK law. So you have two pieces of law doing similar things, and this is a cause of confusion. So what you tend to find, because one law protects against killing and one law protects against disturbance, and these get confused all the time, that you end up with prosecuting officers actually in the UK sometimes putting the wrong law forward to prosecute under, and that means the case will fail. So it's not ideal. So what about in Jersey, they ask? Well, it was until 1950, it was presumed that all international treaties and agreements that the UK ratified would be automatically extended to the Crown dependencies. And following a Foreign Office circular in 1950, it was decided that this wasn't the case, that Jersey would actually have to request that conventions were actually extended to the island. And for them to do so, they had to have their own laws in place to allow for those particular conventions to exist locally. So The Bonn Convention, interestingly, was actually extended to Jersey at the same time it came in 1985, but this wasn't the case for the other conventions at hand. So in 1999, the Bailiwick requested that the Eurobats agreement be extended to the Bailiwick, and was actually told at the time that it was actually needed a law in place to protect wildlife, amazingly, because it was one of the actual requirements under Eurobats. So on the 20th of July 1999, the Conservation of Wildlife Jersey law was adopted by the states of Jersey, and this came into law on the 12th of June 2000. And because this law was seen to be compliant with the different conventions, and the UK said so, then it enabled Berne Convention to be extended to Jersey as well. So all of these were in place in 2002. So from about 2000, bats had legal protection in Jersey, and before that, they really didn't. So when this law came into place, again, it enabled Jersey to ratify Eurobats and the Berne Convention. However, the law was not fully convention compliant, and nobody has actually been successfully prosecuted under this law. Because the burden of proof for actually knowingly committing an offence actually has to be proven in a court of law, and this could be quite difficult. So you may ask, why was it compliant with the Berne Convention? Well, it didn't actually protect any breeding or resting places of protected species, and it also had a defence that anything could be done in a dwelling house in relation to protected animals. And the way it was written, it didn't define a living space of the dwelling house, it just said dwelling house for bats, and that meant that if people had bats in their lofts, were they or weren't they protected? It's a very good question. So this law needed updating. This, by the way, was probably a mistranscription from the Wildlife and Countryside Act, because you got two articles and they copied one but not the other. So in 2000, well, very recently, earlier this year, a new law came into effect in Jersey, only in June. And this updated the local wildlife law and provides a flexible framework that reflects different levels of protection for different wild animals within the island, and hopefully will allow for a more effective, efficient system of regulating and enforcing activities affecting protecting species. We'll have to wait and see. So that's an overview of the different legal texts that protect bats. What I'm going to do now is rattle through quite a lot of Eurobats in 18 minutes or less. So we're going to start with light pollution. So light pollution impacts on many different species, be it insects, turtles, and of course, bats. Light pollution can cause bats to be entombed within their roost. If you light up the outside of a roost, a bat may never emerge again, and you'll end up with an entire dead roost. And Eurobats has a resolution that recommends that parties undertake a number of actions to protect bats from light pollution. So it asks parties to acknowledge that artificial light negatively impacts upon bats, and says that it should be avoided wherever and whenever possible, and that parties should consider artificial streetlight projects in conjunction with bat legislation. So really, if you're lighting a road, you should do surveys to make sure you're not impacting upon bats. It also puts a lot of duties on parties when it comes to actually looking that artificial light is not impacting by making people undertake assessments, ecological impact assessments, and make sure that these are actually undertaken by experienced and qualified ecologists, it states. It also says that countries should have their own guidance when it comes to light pollution, but they did publish their own, so there is some guidance there. So what have English laws and policies and guidance done when it comes to light pollution? Well, they've done a bit, in fairness. So there was an acknowledgement that light pollution can be a source of annoyance to people. It can be harmful to wildlife, waste energy, detract from the enjoyment of the night sky. But there is only 1/5 of England that the skies remain completely free of light pollution. In 2003, the House of Commons actually said that light pollution was becoming an increasing problem, and they actually put forward that it should become a statutory nuisance, and it is. So artificial light emitted from premises that's prejudicial to health or a nuisance is a statutory nuisance. That helps people, doesn't necessarily help animals. The National Planning Framework in the UK also has light pollution included within it. So it states that people should limit the impact of light pollution from artificial light on local amenity, intrinsically dark landscapes and nature conservation. So that actually makes local planning authorities look at light pollution when they're developing areas. So this can be new housing estates, new developments on roads, etc. And what's interesting here is that light pollution is considered underground conditions and pollution under the National Planning Policy Framework and not under the Habitats and Biodiversity section. So again, it's looking more towards human side of things and pollution rather than looking at it in the context of species. And the UK government guidance on activities that can harm bats does not include installing lighting in a roost or outside a roost entrance. So it's not explicitly there as a problem for bats. So what about guidance? Well, it's actually fallen to charities to write the guidance when it comes to light pollution for bats. So you have BCT, who have written guidance along with the Institute for Lighting Professionals. It's not the government that did this, it was charities. But what is important is that local planning authorities do look at light pollution when it comes to development, at least in the UK, she says. So it does make sure that people undertake impact assessments, but it also recommends that you do post-installation monitoring of light pollution at developments. And this is really difficult because properties change hands, and can you compel the future owner of a property to undertake something where somebody else has signed up to it? It is a problem in the UK, and it will be a problem here if we try. So what is interesting as well is that it really does try to compel ecologists to undertake this work, whereas this is work that should be done by lighting professionals. So it's another person that needs to be involved in the monitoring of bats and of sites when it comes to light pollution. So climate change is another interesting one. And why I say this is that at the start it might seem like an odd association, but actually when we start looking at reducing carbon and we start looking at airtight housing and we start looking at governments starting to insist on installation policies, you're starting to see these come into conflict with bats. So we'll come on to that in a second, but another one to do with climate change, of course, is trying to reduce our impact when it comes to carbon. So we're moving towards renewable energies. And renewable energies themselves can impact on bats. A study in 2016 stated that wind farms could be killing 80,000 bats a year. That's just in the UK. And whereas environmental impact assessments are taken to inform decisions about where wind farms should be, this doesn't seem to be working terribly well. They seem to be quite ineffective at protecting bat species. So bats can actually directly impact into wind farms so they can hit the blades. But more importantly, if they go near to a wind blade, they can actually get a barometric injury, which is the air pressure difference is enough to knock them out the air and kill them, so they die with internal injuries on the ground. So case law about wind farms tends to be more about local objections from people. They don't want them there, they don't want them next to their homes, they're noisy, they don't look good. They're not really about bats. Bats get included as a secondary argument when people try to say you might impact on the bats. Now, there is guidance in the UK about where you should put wind farms, but this is actually really out of date. It was interim guidance from 2014. It hasn't been updated since then. And it states that there's inadequate evidence base to show that it's having a significant impact on bats. Now, since that time, there's been an awful lot of evidence gathered by different organisations to show that bats are impacted directly by wind farms. But is the death of a bat of a wind farm a deliberate act? If you put a wind farm in an area with high bat use, are you deliberately impacting those bats? Is it reckless or not? So we know wind farms kill bats, and we know that they could actually have a cumulative effect and become significant on the local populations of bats. But are the deaths incidental and ongoing, or are they deliberate? Well, there was a court case in 2013 whereby somebody took company to court due to the fact that the wind farm that was going to be built in their area would impact on the birds and bats, and that this was against the law. Respect to bats, the suggested offence under this law was actually the habitats regulations that stated a person who deliberately captures, injures, kills any wild animal or any protected species guilty of an offence, with the case being that the operation of the wind turbine is known to kill bats, and therefore the act of killing can be considered deliberate. Now, the judgment concluded that deliberate needs to be read in conjunction with the Habitat Regulations, Article 12.4, which states that states should actually have a system to monitor incidental capture and killing of animal species listed in Annex 4. And in light of the information gathered, member states shall take further research conservation measures as required to ensure incidental capture and killing does not have a significant negative impact on the species concerned. And what they actually ruled in this case is that actually the killing of bats was considered to be an ongoing activity and did not fall under the definition of this guidance and therefore wasn't deliberate. So that's an interesting interpretation, but that's one that we have from the UK courts. Now, again, when we start looking at carbon neutrality and start looking at insulation materials that we use in buildings, obviously people are encouraged to insulate their house these days to stop heat escaping from their house, to reduce the actual bills that they have, but to reduce the amount of fuel used to heat a home. But this can also impact on bats as well, due to the way that insulation methods are done. So we're moving towards zero energy buildings. And in fact, there's an EU directive for this, which is directly transposed into UK law, that says that the country must undertake a raft of measures to ensure energy efficiency and performance of buildings. And new buildings must be built to a minimum thermal standard. And the particular way it's been put into UK law, although in the EU law there are get-out clauses for old buildings, there isn't within the UK law. So again, it becomes difficult. What do we do with these buildings? But the UK is also bound by Directive 2004/35/CE, which is actually looking at environmental liability with regard to protection and remedying the environmental damage to protected species. So they're actually meant to prevent, mitigate and compensate against damage to protected species under this law. And again, under Eurobats, there's an entire resolution about insulation materials, so saying that national legislation must be put in place to make sure that these are actually done properly so that they do not impact upon bats. So the guidance also mentions the cumulative impact, because if you destroy bats in one roost, you might not have a significant impact on that species. But if you destroy them across an entire island, for example, then that would be a significant impact. And the United Kingdom also, of course, has a way to help people pay to put loft insulation in, cavity wall insulation in, etc., to try to cut down on the greenhouse gas emissions, to try to make houses more energy efficient. And Eurobats actually goes as far as stating that EU-financed schemes to promote the installation of insulation are in conflict with policies to conserve bats. So that's straight out of Europe. So you can start seeing these problems now. The ones on the pictures on the sides of the screen here are actually from Eurobats guidance. So this is insulation being pumped into a wall, bats actually having this stuck to them and dying. The one here again is people having their wall insulated, where these hundreds of bats were just pulled out of the wall and just dumped into a bucket. And again, one at the bottom is fibres actually spun around bats. So this is an ongoing problem. So where does Jersey sit with this Eurobats guidance? Well, we fulfil the guidance under Article 3.1, where it states it's an offence to knowingly kill, injure or take a bat. That fell under the old Conservation of Jersey Wildlife Law and falls under the new law as well. So in essence, we comply with the overranking articles of this, but it's difficult to see where we actually comply with some of the resolutions themselves. Where do we comply with the insulation, with the lining materials, with the climate change, with the light pollution? Are there any local guidances on this? And finally, I'll come on to bat crime. So we've looked at all these instances of injuries towards bats to do with climate change, to do with how they might be considered protected or not under different laws. But there is bat crime itself. And bats are actually a priority species in the UK, with the Wildlife Crime Agency looking at bat-related crime and looking at prosecutions. And this is actually quite an interesting one, because police forces can actually bring forward charges under the CPS, or they can take advice from others about the likelihood of prosecution. And the CPS itself on their website, it's not terribly clear which law do you actually prosecute somebody under. So going back to the previous slides about do you prosecute under the Wildlife and Countryside Act or the Habitats regulations, it's not clear there. So no wonder police authorities are having problems bringing forward the correct prosecution. Since 2001, the Bat Conservation Trust has started producing annual reports detailing bat crime across the UK. And in 2016, a total of 153 alleged bat crimes were reported to the police. But only 3 of these cases have actually been to court, proceeded to court on an annual basis. So the prosecution rate is not very high. The fines are also not very high. So in this case, 2017, the owner of the property got an £83 fine and the builder 153 and was made to pay some costs. It's not great. So what's the incentive to not commit crime? In 2016, for the first time, somebody actually used the Proceeds of Crime Act when it came to destruction of a bat roost. But this was only applied to how much it would have cost to do an appropriate assessment when somebody hadn't done so. So again, how's this going to help? In 2019, somebody actually got a decent fine, £18,820, but no Proceeds of Crime Act in this case. That was just the amount of fine that the person actually got from the judge. But in the same year, a £750 fine. So there's no consistency in the amounts that people are being fined for bat crime. So what I would suggest is that you need to start looking at Proceeds of Crimes Act when it comes to bat crime. If you hit people with the amount they made from actually doing the crime, then it might actually stop them committing the offence. And you can see this for trees. People are now starting to actually get hit with Proceeds of Crimes Act fines for undertaking illegal acts to trees in the UK. So if you suddenly cut down a tree to actually develop a new building, you get hit with a fine of the cost that you can sell that new building for. So this is the way forward, I think. This is actually the biggest bat-related fine so far, is £600,000. But again, not a Proceeds of Crime Act. This was just a developer who killed a bat roost, and the judge was actually quite like bats. So what's the way forward? Well, we can look at sentencing guidelines. The Scottish are looking at this. The English aren't, and we don't have them here. So we could look at guidelines that actually set what should be the appropriate fine. And this already happens with some environmental crimes. So you'll see this when it comes to some of the environment legislation, including pollution in the UK. So if you actually knowingly commit well, it's not even knowingly, if you commit an offence and it's a large offence, you get a large fine. Some of the water companies in the UK have got several £1 million worth of fines. So surely we should move towards more of this, a strict liability offence, rather than looking at these different offences that require knowingly, deliberately, intentionally. No, you committed the crime, you pay the price. And again, if this can happen with pollution, why can't it happen with wildlife crime and protected species? So to go through the conclusions quickly, because I know I've gone through that quite fast. The main conventions of Eurobats and all these European regulations have been actually covered by governments, both in Jersey and in the UK. But it's fallen to professional bodies such as SIEM and BCT to actually produce professional guidance that is required under the resolutions of some of these particular laws. As jurisdictions move towards no carbon or carbon neutral status, we're bringing that into conflict with bats and bat protection, and we need to be careful. We need to make sure that appropriate monitoring is carried out to make sure that people aren't entombing bats into roofs or causing further problems. When we look at renewable energies, again, we need to make sure that we're not negatively impacting on bats. If we're killing 80,000 bats a year in the UK from wind farms, and these are considered to be incidental losses of ongoing operation, how are we protecting bats? So, you know, it's a tricky one. So the crimes are not enough, the penalties are not enough. We need to actually fine people more. We need to look at sentencing guidelines. We need to make sure that judges across the country are actually fining people equivalently. And we need to make sure that we start looking at the Proceeds of Crimes Act against people should they require it. So if you develop a loft in Jersey and destroy a maternity roost of a grey long-eared bat, you might get fined £2.5 million. This would be an appropriate fine. So what about Jersey? Jersey's pretty compliant with Eurobats, but it isn't terribly compliant when it comes to the resolutions. We only mention light pollution once in our new draft interim island plan, and that is not in respect to biodiversity. It's in respect to we don't want the green backdrop zone having lights in it. There is no local guidance concerning the impact of factors on bats, with really only controls of building work and planning laws protecting bats far more than the wildlife law. We'll have to see how the new wildlife law works out, whether anyone gets taken to court, and ideally somebody's going to get a large fine and think about bats when developing or when enacting some of this carbon neutrality strategy moving forward. Thank you.